We've already been called to court once today, so we're a little bit confused. Thank you, everybody. Please be seated. Our next case set for oral argument is State of Iowa versus Miranda Rincon. Ms. Regenold, you may go first.
May it please the court, counsel. I'm Rachel Regenold of the Appellate Defender Office here on behalf of Miranda Rincon. The scope of the automobile exception doesn't exceed or expand beyond the confines of the automobile. This was firmly established in Wyoming versus Houghton in 1999. And yet the district court in this case relied on State versus Eubanks, a 1984 case interpreting the automobile exception under the Fourth Amendment. And the court found that when Ms. Rincon exited the vehicle with her backpack in hand, that the automobile exception allowed the court to find it could be searched. We believe that this decision should be overruled and that the case should be reversed and remanded because the automobile exception does not apply once an item or container is outside the automobile. So this was this.
I mean, isn't a better rule that if it's inside the car at the time of the stop, it's fair game if there's probable cause under the automobile exception. Otherwise, you could have somebody just run off with it.
So, Your Honor, and first I want to clarify, I think Eubanks held that it wasn't the time of the stop, but when probable cause arose, which is one of the disputes that the parties have here. I don't believe it is because that allows the automobile exception to basically swallow up the constitutional protection of the Fourth Amendment and Article 1, Section 8. And that's because once Ms. Rincon or any other passenger exits the vehicle with their purse, backpack, container in hand, the constitutional protection that was lessened while it was in the automobile is restored to that item.
Let's change the facts a bit, but maybe not a whole lot. All right, so let's say, in this case, the police found these open containers and they're going to proceed to search the vehicle. And let's say hypothetically Rincon is outside of the vehicle, and as she sees the police about to start searching the interior of the vehicle, she reaches in to pull her backpack out. What is that a different scenario? Does she have the same protections there?
No, Your Honor, once she exits the vehicle, then that protection is not the same. So she makes the decision, any passenger makes the decision when they exit the vehicle, whether to leave the item or the container in the vehicle at that time. So once she exits, I believe the officers could say that she could not then remove the item.
Can you repeat that again?
I said once a passenger, such as Ms. Rincon or anyone else, exits, then I believe the officers could prevent her from going back in to then remove the item.
People in the car to leave bags in the car when they get out of the vehicle?
I believe at least a Court of Appeals decision has determined that would be an unlawful seizure, Iowa Court of Appeals. I think there's conflicting authority on whether that could happen, but I do believe other courts have also held that would be an unlawful seizure at that point, that to say that she must leave the item in the vehicle.
So
we'll give the option to say we're going to impound this vehicle. Is there anything that you want to remove? Sometimes that does occur, of course.
Let's say that the police officers say, we're going to search this car, everybody out, and she takes her backpack with her. They can't then search the backpack?
At that point, they would need reasonable suspicion, Your Honor, that she is armed and dangerous or a threat to officer safety.
So here, there's probable cause that there were open containers, right?
Dispute probable cause on the open containers, Your Honor.
On what grounds?
This was a parked motor vehicle, and as a lower court decision has decided, a parked motor vehicle, they cannot be charged with open container.
And then
probable cause, that would not give them probable cause or be charged.
Second, the methamphetamine that was found in the door, wouldn't there be probable cause to search the vehicle based on that?
All the passengers had exited at the time that there was methamphetamine found in the door, and they had taken their containers with them. But yes, that would give probable cause at that time.
Why wouldn't the rule just be more fact-specific when it's probable cause of something, right? So if it's probable cause that people in the automobile may have possessed drugs, then that would extend to any containers in the vehicle that could hold drugs. If it was probable cause of an open container, then it would be probable cause to search any bags that could possibly hold a container. So you couldn't search something, you know, the size of a little coin purse, but you could search a backpack. And then the point of the search corresponds to the scope of probable cause. I mean, doesn't that make sense?
You said it in your first sentence. You said any container in the vehicle. That's the problem. This container was no longer in the vehicle.
Was in the vehicle.
And I would disagree, Your Honor, because that violates the clear language of Houghton, which repeatedly said that the exception applies to items, containers in the vehicle, within the vehicle, inside the vehicle. And then we have...
Because that was the facts of that case. It did not say, unless, and correct me if I'm wrong, that it could not extend to bags taken outside of the vehicle.
Majority did not. The concurrence by Justice Breyer did say that it applied to only items within the vehicle. And it's important to note at the oral argument in Wyoming versus Houghton, one justice did pose this very situation, really. Somebody exiting with their container, their purse, their backpack. And yet, despite that, being aware of that possibility, the court still explicitly used the language that it did.
The fact that it's a stolen car, isn't that of itself probable cause to search the contents of the car?
That, Your Honor. First of all, the state makes that argument as well. First of all, I would argue the officers are called in twice, or I believe at first in the minutes it says the officers ran a search through their computer, their in-car computer. And we argue in our brief that gave them reasonable suspicion because they had to do a confirmatory call to have the dispatch check Lenser to confirm that it was in fact stolen. So at the time they're approaching this stopped car, they have reasonable suspicion that it may be stolen based on that initial search. And so they're investigating. That's why they ask the gentleman approaching the driver's door, is this your car? No. The other matter is the state hasn't made clear what items supporting or evidence of theft of a motor vehicle they believe they would find in the vehicle. In years of representing individuals on stolen vehicles, I'm not aware of any item that would have been in my client's backpack that they could have searched for. This isn't a case where we have a mismatched license plate. Sometimes you see cases where they've put a different license plate on and it comes back to obviously a different vehicle. Then they might want to go in the glove compartment, of course, to see who the true registered owner is. But I don't believe there's any evidence that they would find in the containers in this vehicle that would show that it was stolen.
Plain view issue?
Certainly, Your Honor. The state, for the first time, raised the argument, the other plain view argument, other than the open containers and drugs. They raised this for the first time, arguing that there was an item in plain view in Ms. Rincon's backpack. So it's a pink backpack that had handles on top as well and had an open pocket with an item sticking out. And this was not raised below, despite the video evidence and the state taking arguably 2 bites at the apple in this particular case. And they are now raising it, claiming that that item was plain view. So we would, 1, argue that the court should not apply the evidentiary exception here. But 2, I assume the court, you're asking more specifically about plain view, not the evidentiary exception.
As I looked at the video, and I know you're disputing whether or not the officer could have seen the marijuana. I think it was marijuana, correct, in the backpack. He approaches the backpack and he says something like, well, there's weed right here, and grabs the pouch right out of the bag without touching the bag. How is that not plain view?
The order of events is a little bit off, Your Honor. So Officer Steinkamp grabs the backpack from Ms. Rincon when she's outside the vehicle, escorts her, takes the backpack, throws it on top of the Des Moines PD SUV. Officer Minahan then comes over, shining a flashlight, and makes a comment, something to the effect of, "You got weed in there." Then he throws up his hands and goes to handcuff another individual. At that time, once everybody else is out of the vehicle, Steinkamp goes to look inside the door. He sees the drugs. Minahan goes to take a look. Then he comes back to the vehicle, to my client's backpack, and pulls out this item. We know with plain view that we have to have the intrusion was justified, discovery was inadvertent, and the incriminating nature was immediately apparent. If those three factors are in place, and if it's probable cause that it was contraband, not just reasonable suspicion, then the officer can seize it. I would argue here, at best, they have reasonable suspicion, because if the officer honestly believed, which since we don't have any testimony or any other evidence other than the videos, because the state did not present that, if the officer honestly believed that it was contraband, he was entitled to seize it at that time, but did not.
What you said, immediately apparent, that isn't the same as immediately retrieved. I mean, wasn't it already on the, wasn't that bag thrown on a cop car and the scene was protected? There was no reason to immediately actually seize it.
Officer believed, since again we don't have testimony, the state did not present this argument below. If the officer believed it was, then he could have seized it at that time. And as the court knows, we are disputing that it was immediately apparent because of the nature of the container.
The video, he says, "Got weed right here," and then they pull out the bag and it's weed. I mean, I know that you think that that's not possible, but he said it. I mean, shouldn't we credit that observation that he made in real time, that he observed it to be weed without rifling through the backpack?
Again, it was reasonable suspicion, but it was not probable cause.
Asking us to overrule Eubanks? Why? I mean, why do we need to, based on what you're arguing?
With Houghton, because it finds that the automobile exception applies to containers outside the vehicle, thus basically obliterating Article 1, Section 8, and the Fourth Amendment. And of course, it's only decided under the Fourth Amendment. Houghton says, and Collins versus Virginia decided more recently, that the automobile exception, the name tells you what it is. It is an exception for items within the automobile. It is not, the government here is trying to expand the reach of the exception to obliterate it, essentially. And the problem with the Eubanks test, this court has said it prefers bright lines. It described in Storm the automobile exception as easy to apply. I would argue, while in Eubanks it was relatively straightforward because you had one occupant and a pair of police officers. Here we have 5 occupants of the motor vehicle. So what happens if we're applying the Eubanks test here? What if only half of the occupants were out of the car with their containers when something...
Let's assume you have a traffic stop and the police bring a canine unit and the dog alerts to the vehicle and you have passengers in the car and they each get out with backpacks. Do the officers under the auto exception in that case have the ability to search those backpacks?
In that case, given that it's involving a canine, I would want to know where the canine alerted. Was it near, because as an additional authority, I cited to State versus Lelm, which is a North Dakota.
Trunk.
Then I would argue, no. They can exit the vehicle, and the officers would have to have some other exception or obtain a warrant.
The cherries go off, and you got a carload of people, maybe up to some shenanigans. Smart ones would stuff everything in your bags and get out, and those bags are untouchable?
Untouchable, Your Honor, if they have a warrant or some other exception, but not the automobile exception.
This for getting the warrant, in my hypothetical, to search the bags that were taken out of the vehicle.
They would have to have a probable cause to support that warrant, of course, and if...
The warrant application to establish probable cause in that circumstance.
If they're not able to, then they don't get to search them, Your Honor.
I mean, doesn't the fact that a drug dog alerts to the trunk establish probable cause to search the vehicle the trunk, and the bags contained in the vehicle. And if that's true, then what is the point or the purpose at that point? If there's already probable cause to search, we know that probable cause extends to all the bags in the car, right?
Except if there's only probable cause, this is Acevedo, in essence, minus the canine. In Acevedo, they only had probable cause to search the trunk for the paper bag of drugs. That's in essence what you have here in that situation.
Sorry, if I may, Chief. Sorry. Doesn't your rule sort of incent passengers, if they have contraband, to hop out of the car quick with their backpacks?
It protects the contents of their items, certainly. Now, if they're hopping out quick or engaging in any other behavior, that might trigger something beyond some type of exigency that gives the officers something additional, probable cause plus exigency, so it gives them another exception. So,
You may wrap up.
with that, thank you.
Thank you, Madam Chief Justice, and may it please the court, counsel. Good afternoon. It's a privilege to be here. So I don't read Eubanks as being inconsistent with Houghton. In fact, the appellant's brief cites Lewis from Maine and Boyd from Kansas. These cases, and Professor Lefebvre's commentary on Lewis from Maine, this is all consistent with Eubanks. Those cases say that the automobile exception extends to cover the container that can contain the object that you have probable cause to search the automobile for, as long as the container is inside the automobile when probable cause arises. Now, I would disagree with the idea that when the passenger takes the container and steps outside, an expectation of privacy is restored. I think the way that it works and that Eubanks accurately described it is within the automobile, once there's probable cause to search the automobile for something, the expectation of privacy is pierced. It becomes reasonable to conduct a search of the automobile and containers that could contain the thing that you have probable cause to search for. And it doesn't really matter who claims ownership, especially because those claims may or may not have basis in fact. Doesn't really matter who claims ownership of any particular container, as long as it can contain the thing that you have probable cause to search for. And if there are facts showing that probable cause doesn't extend to that particular container, then you can't search it. If it's too small to contain the thing you're looking for, if it's in a part of the car that was completely inaccessible to anybody in circumstances where that would be the basis for the search, facts can dissipate the probable cause that you would need.
If the meth that was in the driver's door was not discovered until after the passengers were outside of the car, including the bag, then does the automobile exception extend to the bag that is now outside of the car?
Then we would need to rely on a different basis for probable cause to search the bag, something that did arise before the bag was removed from the car. Now, I do think there is one thing that the reply brief is correct about, and that is I was inaccurate in saying that that the minute said that Officer Johnson noticed the methamphetamine before the passengers got out. What it really says is, as Officer Johnson began speaking with the other occupants, assisting officers observed an open container of Hennessy and 2 small plastic baggies containing a substance like methamphetamine sitting inside the front driver's side door handle. So it's as Officer Johnson's beginning to talk with the passengers, and that takes a good amount of time before, while the other officer is standing on the other side, and that's even before Officer Steinkamp comes up. So that observation, and the door is wide open at that point, that observation, now we go back and forth in the briefing. I think there is a pretty good basis supporting the notion that the officers knew that the methamphetamine was there, but I don't think you need to find that to apply the automobile exception here because of the open containers and also that the car is stolen. But we're focusing more on the open container offense here. Now, I know that opposing counsel is saying that there's no probable cause for an open container violation because the car wasn't in motion at the time. I think that the decision she's referencing is Phillips from the Court of Appeals. The difference is that in Phillips, there was no reasonable suspicion or probable cause that the car had been in motion while the containers were open. And here we have 4 people, passengers, who all insist they were getting a ride. And in fact, Ms. Rincon had no idea where she was. So definitely probable cause to believe the car had been in motion. It's true, yeah, thank you. Key in the ignition as well. So Phillips is distinguishable there. Also, aiding and abetting OWI is a thing in Iowa. State v. Saturn is a important case that establishes that. All this to say, you don't need, the timing of the discovery of the methamphetamine is not material to the decision in this case. Now, to talk about plain view, Justice McDonald, I agree with you that the evidence from the video is clear. I think it's apparent, especially in addition to what you said already. At 3 minutes and 24 seconds on Exhibit B, you can hear an officer talking with Ms. Rincon, and she's kind of asking why she's being detained, why they're searching her bag. And one of the things he says to her is, "You had weed in plain view." He's explaining to her the basis for further interaction, and that's one of the things he says to her in that moment. Also, if you look at Exhibit A at 15 minutes and 30 seconds, that's an earlier close-up of the bag. Now, I think it is true that there are parts of the bag that are opaque, but there's also a good deal of the bag that is transparent, especially the ends, the part that would be poking out of the flap, and you can very clearly see through them, and you can see the material inside. And it was readily apparent to the officer who identified it and described it. And Ms. Regenold says, if it was apparent to them, why didn't they just seize it? The officer, I think it's accurate that the scene, identify it, walk away for a second, come back, and then seizes it as the first thing in the subsequent interaction with the backpack. First thing, take the bag right out of the front flap before opening any other part of it. And
fair enough, but there wasn't a record developed below, and ordinarily we allow cross-examination, and I assume the officers would have testified to some extent about plain view if that was brought up by the state, and then, cross-examination would try to, undercut whatever the theory was. We didn't have that here. Isn't that problematic?
Well, I think that, and so I recognize that that's not, I would prefer more of a record. This is motion to suppress in April 2020. From the transcript, it's apparent that they're already having technical difficulties just getting the lawyers and the judge to be able to hear each other. But I take your point that it doesn't change how we should apply the law. The videos, I think, are already enough record that it becomes plainly apparent that this is in plain view. And the trigger for the ability of this court to exercise its discretion to apply the evidentiary exception from DeVos is it.
Let me, I do. We're communicating just fine. There's substantial evidence to support your view of plain view, but we just didn't have it tested in any kind of adversary crucible. Now you say you're advocating, well, it wouldn't have made any difference. If you look at the video, it's clear enough. He does say plain view. End of story. But, things that seem apparent on appeal sometimes don't turn out that way. And whether this is a case where that might occur, I don't know. But ordinarily, before we apply DeVos, ordinarily we have a kind of a crystal clear 100% no miss proposition that doesn't require record development below? I mean, I'm just drilling further in the same general area. Please.
And this court can decide to go that way and say it's, this needs to be developed more before there can be a ruling on plain view. You could say that. I think that it is apparent. I think the bigger point that I want to make is that DeVos, this exception, does apply to rulings on motions to suppress because they are about the admissibility of evidence. That just like mid-trial rulings about the admissibility of evidence, that now it's the same kind of situation where when an objection, so take Dessinger, for example, the evidence comes in on a purported theory. And then on appeal, this court can say, well, that theory was bad and the objection on that basis of that theory should have been sustained. Are there alternative theories for the admission of the same evidence? Now, it doesn't actually matter if they were advanced or ruled upon.
We don't, and we don't require any further explanation. That is right. But
if instead of testimony, you had a video of the child's statement and you could watch it and you could say, from the video, it is apparent that this particular exception applies to the hearsay rule. And I'm just inviting you to consider the idea that the way in which it may be apparent from the record can come in different forms. In Dessinger, it was mostly testimony, and in this case, it's a video. Now, the thing they have in common is it's not unfair to apply a different rationale for the same result on the admissibility of evidence, because one reason it's not unfair is because it's not ambushing the district court. It's actually a cavalry for the district court.
I'm worried about making sure that we have an adversary system that's functioning. And we just don't know what effect the cross-examination might have had if it was afforded. We just don't.
It's interesting because my experience lately has been that officers will frequently say, you know, when their memory is not perfect, they'll just say, well, the video shows what it shows. And they return to the video as the ultimate. But I take your point that we don't know exactly how that would have played out. Just like in a mid-trial ruling on admissibility of evidence, a party preserving error on a, you know, should have sustained my objection to this evidence, my challenge to it, and didn't. And then in order to create fertile ground for the appeal, then has to make a record that forecloses or at least calls into doubt alternative routes for the same result on admissibility of evidence.
Motion to suppress is a lot different from, you know, a garden variety trial objection, and that's why we require the motion to suppress to be made before trial. I mean, Ms. Regenold made some pretty good arguments and had kind of a lively debate with some members of our court. Why shouldn't the trial attorneys for Rincon have had that opportunity? I mean, are we, you know, should we be bailing out the prosecutor who should have made this argument below?
I think the more correct way to view it is bailing out the trial court rather than bailing out. Now, I recognize that the prosecutor didn't make this argument, but the fact that it wasn't made by the prosecutor doesn't, I mean, the defense can also call witnesses at the hearing on the motion to suppress or request a hearing where witnesses can be called. I also think that, you know, you're saying that a motion to suppress is handled pre-trial because it's more complex. Well, that just, I think, makes it more fair to apply this exception to rulings on motions to suppress because they're not in the middle of trial. There's more of an opportunity to zoom out, look strategically, and say, okay, and there's definitely a strategy to preserve this for appeal. That's why we have a stipulated trial on the minutes of testimony and not a guilty plea. So when you're thinking, you know, planning on the appeal, how am I going to do this? That's your cue to, if you don't already have a record that forecloses alternative bases for admission, then you need to make it. And you need to do that in order to establish. Now, the other component, and I think one of the things that goes unsaid in the definition of the evidentiary exception is Rule 5.103, that error in an evidentiary ruling is only cause for reversal if it prejudices a substantial right. And then I think aligns with the discussion in Carroll. In Carroll, the U.S. Supreme Court said the defendant is raising an argument here that the record at the time of the motion or the pretrial consideration of the search wasn't apparent from that the search was legal, that there was probable cause. And the court says, well, it became apparent from trial. So on this whole record, the whole record forecloses the claim that there was a violation of constitutional rights. Even if it wasn't apparent pretrial, it was apparent from the expanded record at trial. And that is striking the same chord, that if the expanded, and this court also, I'm sorry, go ahead.
Part. The expanded record, I mean, our case law is pretty clear. Whatever came in trial can also be considered on the evidentiary point now. So you're by that. But once again, at trial, the issue of suppression based on plain view wasn't at play at all. And so you wouldn't expect trial counsel to make a record of trial any more than they did at the motion to suppress on an issue that didn't appear to be before them.
Although I think that's partially correct, although a strategy aimed at appeal is, has to protect the record along the way. There's also room to say, to tell the court, new facts have come out that are different from the facts that came in at the hearing on the motion to suppress that establish that our client actually does have a right to exclusion, sort of a motion to reconsider.
I mean, frankly, at trial, plain view wasn't an issue.
Any issue at trial, the minutes just came in, and in fact, the minutes tend to establish. Well, I also want to say that we're not even stating the rule completely about the expanded record, because Schubert says the record from trial may be considered to support the ruling on the motion to suppress or to affirm the ruling. That the idea of facts at trial coming in to attack the ruling on the motion to suppress rendered earlier, that strikes us as unfair. If the district court is not given an opportunity to consider those, the legality of the search or seizure in light of those facts.
Say that we on appeal can decide that there was plain view, even though the district court and the defendant didn't have an opportunity to cross-examine.
Well, but it can only be used, and it seems like it's state versus defendant, but it's really appellant versus appellee. That expanded record can only be used to affirm what the trial court did, the ruling the trial court made, and say the trial court may have gotten there for the wrong reason, but a correct ruling, and given the facts we know now, I'm sorry, I see my time's expired, if I can just have a brief moment. Thank you. Given the facts we know now, a correct ruling would have established that the same evidence would have come in, that there was no right to its exclusion, and so we affirm on that basis there's no point to a remand. Justice was done, and I think that's what we have here. Thank you.
Let's be clear. This court would not be bailing out the trial court. It would be bailing out the prosecutor, because it was the prosecutor who had 2 different hearings, who had all the police reports, all the videos, and the opportunity to present evidence before the court, and failed to do that. So the court didn't know about this argument, and as Justice Apple pointed out, certainly the defense isn't going to point out, oh, here, you could use this exception to convict my client.
The plain view issue. Respond to the state's argument about the open container issue. Does it matter that the car was previously, it would seem, in motion and running at that time?
I think when we're talking about the fact that it was running, which it was, the keys were in the vehicle, it was Christmas Eve, and it was clearly a cold night. I think that's conflating OWI with open container. We know in OWI, if the vehicle is running, that's operating, but you would also have a driver in the driver's seat, which we do not have here. So Phillips, the state is correct. It's State versus Phillips that I cited to, and the court said, yet the use of the term passenger, a person who is traveling from one place to another in a car, bus, train, ship, plane, airplane, etc., and who is not driving or working on it, infers motion of the vehicle. So that decision of the court was relying on, of the Court of Appeals, to be clear, was relying on the fact that the vehicle in that case was not in motion, as this vehicle was not. The officers never saw this vehicle in motion. They saw it parked. They saw the driver, presumptive driver, up at the door of the apartment complex. They ran it through the computer, and when it came back reported stolen, they swung around and pulled up behind it. So yes, I do believe the fact that it was not in motion, not the fact that it was running, is key here. And as to the state's argument of aiding and abetting OWI, that is indeed a thing here in Iowa, as he said. But the problem is we don't even have a driver here. We have a presumptive driver. We have other people that identified him as driving. The officers never witnessed him driving. There were no field sobriety tests, no blood alcohol tests, no tests for drugs in his system. So we have no aiding and abetting of OWI, nor do we have any testimony or evidence that the others were encouraging him to drive, as I cited to a case where the defendant was convicted of aiding and abetting OWI because knowing the person was drinking, he asked him to drive him around to various fields in Iowa. We don't have that here.
Rincon say she had just gotten picked up from a friend's house and she was going home?
She said that she had been at her sister's and she needed a ride home so she could get to work in the morning, yes.
Basis or sole basis for requesting that Eubanks be overruled is that you believe it's in conflict with Wyoming versus Houghton?
It's in conflict with Wyoming versus Houghton.
And think those can be read consistently. Do you still contend that Eubanks should be overruled for some other reason?
I have not contended any other reason, and we would also argue that even if this court does apply Eubanks, that the state has not met that test in Eubanks because probable cause had not arisen before Ms. Rincon and her backpack had exited the vehicle.
All right, let's back to the open containers. If the court is of the view that there was sufficient evidence that the vehicle had been in motion and viewed the open containers prior to the search of the backpack, if those are the facts, you lose?
So just to make sure I'm clear, so you're saying if the officers believed the vehicle had been in motion or had some evidence that it had been in motion, other than what type of evidence are we talking about? Observation by the officers, or are you saying just admission? Well, we have the driver who gives conflicting statements about he wasn't driving, they threw stuff on my side, so it's a little hard to rely on what the driver says.
If the officers, at the time they viewed the open containers of alcohol, had reason to believe that the vehicle had been in motion recently, accept that as being true. I know you want to challenge that, but accept it as being true. If that is true, does that mean you lose the motion to suppress?
I don't think so. I don't think there's evidence that there could be open containers in Ms. Rincon's backpack. The statements from the others were that it was the driver's alone, that he was the one drinking from that, and there was no evidence that Ms. Rincon took part in that or had any.
Yes, but counsel, I mean, the backpack was big enough to hold a flask or a bottle, wasn't it?
It was, but it was also full, Your Honor, so I don't believe, based on my viewing of the video, that it could have contained an open container.
Beer, kind of the top screwed on and half consumed?
I mean, couldn't it have been full of alcohol? One of the things that would fill it up?
Since we're at it.
That might have been rather messy when the officer slammed it on the hood of the car, Your Honor. No, I don't believe so, Your Honor. Your Honor, thank you for hearing our argument today. We would ask this court to reverse and remand as well as overturn State v. Eubanks. Thank you.
The case of State versus Rincon is hereby submitted, as well as the oral argument in the interest of LB. Court is adjourned for the day. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.